morning, my lords and my lord. I appear on behalf of the appellant, together with Miss Schofield. My learned friends, Mr. Reed, Casey, and Mr. Tippler, appear on behalf of the respondent. My lords, what I would propose to do in relation to the appeal is to first make some opening remarks, identifying certain elements of the case with respect to the matters upon which the appeal relates to. The second would then be to go to the code and take you perhaps at a canter through the code so we're familiar with the provisions. And then thirdly, to get on to my submissions in earnest as to what it is we submit.
Yes, well, I can tell you, Mr. Clerk, that we obviously read the decision of the Upper Tribunal. We've read the skeleton arguments, we've looked at the code, and we've read the Supreme Court decision in Compton Beach.
Thank you, my lord, for that indication. Perhaps then when I come to the code I can take it a little bit more quickly. I still believe that it is worthwhile just going through the provisions that I'd like to look at and then identify any elements that perhaps I consider relevant for your consideration. In making my submissions, I shall refer to the superior landlord as Gencomp, albeit it's changed its name. Gencomp is used in the skeleton arguments, that seems sensible. I shall also refer to, if I can remember as I go through it, as the appellant as APW. I may lapse, but in most cases I'll refer to the appellant as APW. So in terms of opening remarks, the first matter, perhaps trite, is that the matter before your lordships is a structural one. It is a matter as to how the code should work with respect to the insertion of a concurrent lease where there is an existing operator's agreement. And I mention that point because it is apparent that the Deputy President saw it that way. My learned friend below made a point before the Deputy President that in some way APW was to be treated as accepting the risk because of the mechanism which it adopted, namely taking a concurrent lease. The Deputy President rejected that as a submission. It does find its way in some form in the respondent skeleton, so I just wanted to raise that. That was rejected by the Deputy President at paragraph 55 of his judgment, but there is possibly a reformulation of that point coming through. As the Deputy...
Well, the problem would apply to somebody who wants to put an extra flat on top of it.
That is so. That is so. So, as the Deputy President said, commercial objectives or risks were not matters that were to be taken into consideration. They could be set to one side. It's just an issue as to how the structure of the code doesn't work. The second matter that I'd like to identify is that it is not a narrow issue that comes before your lordships. The Deputy President made it clear that concurrent leases were, quotes, not unusual, unquotes, paragraph 56, were, quotes, not an uncommon form of property arrangement, close quotes, paragraph 107. No doubt your lordships will be familiar with the concurrent lease arrangement, and it's commonplace as an investment vehicle, particularly with respect to pension funds. So we submit that the issue has wider implications for the operation of the code. It's not just a case of APW, it's a much broader number of arrangements where overriding leases have been inserted and where if there's an operating agreement in situ could cause difficulty, particularly with respect to redevelopment. It is not a narrow issue because it involves a consideration not just of the right of renewal, but also of termination because of the identical wording which one sees both in paragraph 33 of the code which relates to renewal and paragraph 31 which relates to the right of termination. The third point is that we are not suggesting that paragraph 10 of the code is inapplicable to leases. That is not our submission. Our primary submission is that paragraph 10 is not exhaustive of the circumstances in which a person may be treated as a party to a code agreement. And we say that, and we'll elaborate on this, that it's impossible to discern any legislative purpose in excluding a concurrent lessee from being treated as a site provider who is a party to a code agreement. The fourth point is that we are not also suggesting that there are two different regimes under the code, one for leases, one for license. We're not suggesting that. It is quite clear when one considers the Law Commission report and the code itself that the wrapper, as it were, is irrelevant. It matters not that the arrangement between the parties gives right to release, nor that it simply is a contractual license. It's all caught by the code. So we're not suggesting a different regime for one type of interest and another regime for a less non-proprietary interest. The fifth point is that the judge encapsulated our submission. I know my lords mentioned that you've read the judgment, but if I may just identify paragraph 88 of the learned Deputy President's judgment. Paragraph 88 is where he summarises what we say. It's in the core bundle, my lord.
Yeah.
Yeah, thank you. And it's the last sentence of paragraph 88.
Could you give me a page in the core bundle?
Yes, my lord. It's page 89. Paragraph 88 is over 88 and 89, but it's the last sentence of paragraph 88, which is at page 89. The Deputy President is identifying my submission. And what he says is that I submitted that the better approach was to construe the word site provider who is a party to a code agreement as comprising not only those persons who fall within paragraph 10.3, but also a person who is entitled to the reversion immediately expected upon the determination of the operator's contractual term, and who is the only person who can confer on the operator the right to immediate possession. That formulation would cover both, we would submit, leases and licenses. It's a reversion on a contractual term, in respect of which we are entitled to confer the right to immediate possession. And there is no dispute, of course, that in accordance with the decision of Compton Beecham in the Supreme Court, we, that is to say APW, is the only party that can confer code rights upon the operator. Gencomp as superior landlord is not in that position.
Yes.
That then would apply to any occupier.
When that, meaning what, my lord? Sorry.
Well, any occupier with an interest would be entitled to the reversion immediately expected upon the determination of the operator's contractual term.
Save where the person that has the reversion has a contractual interest only. Paragraph 10 confines itself to where the grantor has an interest in land.
Yeah.
So the way the code is intended to work, it seems to us, is that where the grantor simply has a contractual entitlement to the site in question and grants a right to an operator, that is a contractual arrangement between them alone. And that is...
If this is right, what's the purpose of distinguishing between the different categories referred to in paragraph 10?
When you say if this is right, meaning that if contractual arrangements where the grantor's interest is purely contractual.
Yes.
Because the policy was to confine rights to those that have an interest in land.
No, sorry, forgive me. So if the proper interpretation is that anyone who has a reversion immediately expectant upon the determination it is thereby party to the
yes.
agreement, what is the purpose of the different categories referred to?
Well,
maybe you'll come back to this when you look at the code itself. You're identifying the argument at the moment.
Yes, perhaps I'm identifying the argument. I'm not quite sure I understand completely what your lordship is getting at. Perhaps when we look at paragraph 10, it will be easier for me to then understand the issue that that is being sought to be raised. Yes, so we submit that encapsulates the issue. The sixth point is that the judge's decision was not only that APW was a party against whom the renewal process could not be undertaken, but equally it was the case that Gencomp, as superior landlord, was not a party against whom renewal could be sought, nor a party who could seek renewal. That I mention only because, as is apparent, there is no respondent's notice with respect to that determination. So that is not being appealed, that Gencomp is not the appropriate party. The seventh point is the judge's solution. The judge's solution in relation to the outcome, as you have seen, was twofold. He said that the renewal could be undertaken in accordance with Part 4 of the code relating to the imposition of code rights. And furthermore, Vodafone, as the operator, could then seek an order against Gencomp, requiring APW to be bound by the Code 4 rights. So there's two elements to the solution. One is you obtain a Part 4 imposition.
I thought the solution was that you obtain the code right from APW.
That's right. So you obtain a code right from APW pursuant to Part 4.
Yeah.
That's the conferral. And then the second element is that Vodafone is then entitled to an order against Gencomp, requiring Gencomp to be bound.
What would be the utility of that during the currency of APW's lease?
Well, that's a good question. Perhaps that's for Mr. Reed to answer, but that was the solution. What is unclear, we say, from the judge's judgment is that second element about binding Gencomp to the paragraph 20, Part 4 imposition. What is unclear is whether that is being made pursuant to Part 5, which is what my learned friend is contending. So that solution, that second element of the solution, is a Part 5 application being made by Vodafone against Gencomp.
Well, I thought the Deputy President said it all happened under Part 4.
Well, if my lord, you turn...
The paragraph 20 just allows you to ask a relevant person.
That's a so.
Either to grant rights or be bound by them. It doesn't specify who.
That is so, my lord. However, there is an element to the respondent's case relating to this second part of the solution. One can see the point at paragraph 122, page 96.
Yes, that's what I'm looking for.
Yeah. He says the answer I will give to the second preliminary issue is therefore the tribunal has jurisdiction to impose an agreement on Vodafone and APW conferring rights under paragraph 20, i.e. Part 4, but he has no jurisdiction to order any of the parties to enter into a conferring agreement under paragraph 34. So no one can confer.
Yes.
The answer to the third preliminary issue is that no order may be made under paragraph 34 for the purpose of conferring a new agreement on Vodafone, but an order could be made making code rights conferred on Vodafone by APW binding on Gencomp.
I read that as referring back to Part 20, to paragraph 20.
Well, so did I. That is how I read it, because what Vodafone have done, they've served a multiplicity of notices, both under paragraph...
Six notices on everybody.
How one can understand them, I don't know. I got lost below, but there's a number of notices under paragraph 33. There are also a number of notices under paragraph 20. The notices under paragraph 20 relate both to conferral and also imposition. And I had read 122, as your lordship had done, which was that it was the second part, making Gencomp bound, was an order under Part 4. In my learned friend's skeleton, what he is arguing is that the order is made under Part 5, because what that does, he says, is bring about a termination of the code agreement between Gencomp and Vodafone. This is an argument that he raises in paragraph 42. I submit it's wrong. I submit that part 5 cannot be applicable. I'm sorry, Molly.
Have the page reference.
Yes, it's page 63 of the core.
Yes, I'm working electronically, so I can't find anything.
Apologise. I'll make sure I remind myself of that. So it's paragraph 42, page 63. This is the skeleton of the respondent. Criticises the UTJ on the basis the new code agreement APW under Part 4 does not terminate the existing agreement. However, this line of argument ignores that there will have to be some form of an order under Part 5 against Gencomp in any event. Any code rights conferred under Part 4 will not bind Gencomp, since Gencomp's interest would predate any new code agreement and not derive from AP's interest. The only way that Gencomp can be bound is by an order of the court.
Sorry, where are you?
I'm reading at paragraph 42, my lord.
42?
Yeah, 42 of the skeleton, page 63.
Yeah.
Sorry. So, just to go over that again, Mr. Reed says APW criticises, etc. This line of argument ignores that there will have to be some form of order under Part 5 against Gencomp in any event. Any code rights conferred under Part 4 will not bind Gencomp. The only way that Gencomp can be bound by code rights conferred by APW is by an order of the court. So, and this is why I raised it as a preliminary remark, so as to clarify this, what my learned friend is doing on this aspect, and we submit it's wrong, but what he's submitting is that he is entitled to an order pursuant to Part 5. It is a form of, in quotes, renewal, because there is, as between him and Gencomp, a confer agreement. So he's utilising Part 5 against Gencomp, and then what he's doing is what I would refer to as flipping or transposing that renewal under Part 5, not to a conferral, because he's unable to do that, because he's not the occupier. He cannot grant code rights. He's unable to confer code rights. So what he wants to do is to utilise this Part 5 claim against Gencomp to then switch it or transpose it into one which is binding, a binding agreement to ensure that Gencomp is bound by the code rights that are conferred by APW pursuant to Part 4. We say that's not permissible. You cannot seek, in quotes, a renewal, close quotes, of a conferral agreement, turn up at court and say, I'm seeking renewal against Gencomp, but by the way, what I'm asking for is for them to be bound by code rights that are being imposed on a separate matter under Part 4 vis-à-vis APW. Now, it may be a purely academic exercise because, as your Lordship said, your Lordship read paragraph 122 as meaning it's an order under paragraph 4, under Part 4. That's the way I read it. But my learned friend is making a different point. He's saying, no, the order's not under Part 4. He's saying it's under Part 5. We say that's not correct. But I thought that was a point that did need clarification. I'm pleased I've mentioned it. So that's the judge's solution.
Just before you move away from that, you made the point, as my lord did, that it's not obvious why you need your code rights to be binding on Gencomp, because you're in possession, you're going to remain in possession until...
Well, I agree with you, my lord.
But suppose that were not the case. Suppose your concurrent lease was going to terminate in a couple of years' time, and what the operator wants is another 21 years. So he does want to have something which is binding on the freeholder as well.
Well, then he can make a claim under Part 4.
Under paragraph 20?
Under paragraph 20.
And
that we say is that's one of the primary purposes of paragraph 20, is to, where your position is precarious, to protect yourself against a superior interest seeking removal of your electronic communications apparatus. That's the point. You want them bound by what's being conferred upon you, particularly if what has been conferred upon you has been conferred upon you potentially in breach of covenant. That's not the case here on the specific facts of this case.
No, but you've made the point. This is a structural thing. You
Yes.
can have concurrent leases like yours, which are going to last for a sufficiently long time that the code rights you're going to grant are going to come to an end before the end of your concurrent lease. But you can have concurrent leases that don't have very long to run,
That is so.
and you need to cater for that
Yes,
as well.
in which case you would make a claim under Part 4. And that, on the termination of the concurrent lease, assuming it does not continue under some form of statutory regime, the concurrent lease lessee's interest would end. On the face of it, therefore, as a matter of normal principles, the
Code rights granted out of it.
the inferior interest would equally come to an end on the term date of the
Yes.
superior interest. But then the operator's rights will then continue under paragraph 30 of the code.
Against the freeholder.
Well, it doesn't seem to work like that. That's a very good question, if I may say so, because when one looks at paragraph 30, it's not clear who it's continued against. What it may simply be continued. It's continued against the site provider. Now, the site provider is a person who has conferred or is bound by code rights. If the superior interest is not bound, then on the face of it, paragraph 30 wouldn't work.
Where's the definition of site provider?
Site provider is contained in paragraph 30, subparagraph 1 of the code, which we find in tab 21 of the second volume. And my lord, I'm conscious you're looking at pages, so I'll find the page reference for that.
436.
Thank you. Yes, paragraph 30, subparagraph 1, page 436. Thank you, my lord. Yes. Subparagraph 2 applies if a code right is conferred by or is otherwise binding on a person, the site provider.
Sorry, just to go back for a moment to paragraph 20. Paragraph 20, start with paragraph 10. That tells you who is bound,
Yes.
as it were, automatically
Yes.
by the what we've been calling a conferring agreement. Paragraph 20 applies where the operator requires a person, doesn't say who,
Yes.
to be bound by a code right. So it's entirely open-ended.
Yeah.
And then paragraph 21 sets out the criteria which the tribunal takes into account, so that if you are, I don't know, you hold a grazing license and you grant an operator the right to install a mobile phone mast on the field over which your grazing right extends, he can apply to have the freeholder bound, and if the prejudice caused to the freeholder is capable of compensation in money, etc., then the tribunal, as I see it, can order the freeholder to be bound by a right granted by the grazing licensee. I don't at the moment see why Vodafone can't apply under paragraph 20 on the Deputy President's solution to have Gencomp bound by whatever rights.
Paragraph 10 wouldn't apply because, of course, the grantor doesn't have a legal interest in land.
No,
the example
but
you've
paragraph 10 is telling you who is automatically
Yes,
bound.
and there's no reason in the circumstances
and
in the...
paragraph 20 is telling you who
Yes.
can be bound
Yes, and that's any
only
person.
because of an order of the tribunal.
Yes, I would accept that. Wouldn't disagree with that as an analysis. So paragraph 20 could bind others, but you're right that paragraph 10 is confined to where the conferring party has an interest in land. You have to have an interest in land to confer code rights. So in the example postulated by your lordship, the grantee could have code rights because it doesn't matter that the grantor doesn't have an interest in land. One simply looks to see whether there is a contractual arrangement falling within the code. Paragraph 3
grazing
is there.
licensee on this example would be the occupier.
But
Therefore, has the right under paragraph 9 to confer the rights. But because the licensee doesn't have an interest in land, nobody is automatically bound by them. So the operator has to go under paragraph 20.
Yes, I agree. The licensor doesn't have an interest in land, in which case the licensee, the operator, can then seek an order under paragraph 20 against the freeholder. I would accept that. That doesn't undermine, in my respectful submission, the argument that we're seeking to present in this appeal. I would entirely accept that analysis. So, my lords, what we would be inviting your lordships to do is to say that the Upper Tribunal was incorrect in concluding that Part 5 is inapplicable to APW. That's the first point. The second point is that we would invite your lordships to find that even if you're against APW on that issue, that is to say that you find that the Deputy President was correct that Part 5 was inapplicable to APW's position, the Deputy President was still incorrect in suggesting that Part 4 was the solution. And then there's a third issue in relation to that second point, it's a sort of fallback position, is that even if the court were to find that Part 4 could be invoked against APW by Vodafone, the fallback position is that that application under Part 4 should be limited only to an application for new code rights, not a, in quotes, renewal, close quotes, because we say that any renewal would be inconsistent with the underlying principles set out in the Compton Beach case in the Supreme Court. So that's what we're inviting the lordships to do. What I would propose next...
Can I be sure I understand what the practical consequences for your client are of the tribunal's decision as opposed to where you want to get to?
Well, the practical consequence of the tribunal's decision is that the tribunal's decision has produced asymmetry where symmetry was intended. It's a completely asymmetrical outcome.
Vodafone can apply under Part 4 on the tribunal's decision and get effectively renewed rights. But you have no right...
We have no rights whatsoever. We are not entitled to seek a renewal.
Can you terminate the existing...
We're unable to terminate because the same wording is to be found in the termination provisions. In order to terminate, you have to be a party to a code agreement. The Deputy President recognised that and warned developers not to enter into concurrent leases for the future.
And you've got a concurrent lease which lasts till
2058.
So throughout that period, you carry on receiving the rent under the code agreement, but you can't.
No,
you can't increase the rent. You can't terminate it.
No, that's right. I mean, it could be suggested that there are other examples which would be more extreme. I mean, we've all seen concurrent leases of 125 years,
or 3,000-year terms.
999 years.
Yes.
This is the we would submit with due respect to the Deputy President the absurdity of the outcome. It's not. It doesn't. It is contrary to common sense, because what can happen is that you could have a scenario whereby the operator says to itself, "Oh, I'm quite happy, thank you very much, with the terms that I'm occupying this site under. I know that my immediate site provider, because it has a concurrent lease, is unable either to renew it or to terminate it. Let's assume that the concurrent lease is 125 years or 999 years. The whole regime that is the outcome of the Deputy President's determination is that the operator is in the driving seat. Part 4 is optional. Part 4 is not mandatory. The operator,
you can't invoke it.
No, the site provider is unable to invoke Part 4. Part 4 can only be invoked by the operator. So the operator can determine when it wishes to invoke Part 4. It may never invoke Part 4. By way of an example, in this particular case, one must be careful not to keep just looking at the facts of the case, because it is a structural issue. But on this particular case, the last rent review was 2013. Well, we're unable to renew. If Vodafone had not implemented Part 4, it could have sat there on a 2013-year rent until 2058 without it taking any action and without the concurrent lessee being able to take any action. that we say is not.
All you could do is go to the freeholder, surrender your lease, and
Well,
get an agreement that they then grant new rights, and then.
That is right. As a consequence of this decision, there have been many attempts at trying to identify workarounds, but we ask rhetorically, can it really have been intended by Parliament that there should have been all of these workarounds to overcome what is an easy fix, which is to treat the concurrent lessee as a party to the code agreement?
Well, you've got, in a sense, you've got the Deputy President on your side, where he says this is a structural defect. That,
Yes.
This is not how the code was meant to work,
No.
and so forth.
Not how the code was meant to work. He has adopted a solution.
Well, he's found a workaround.
He's found a workaround for the operator,
Yeah.
but that's
But
why
you say it's not a workaround for you.
it's not a workaround for us at all. It's completely asymmetrical.
Well,
And
we tried in this court to find a workaround in Compton Beecham, and were told it was quite unnecessary.
some form of workaround has now been found by the Supreme Court. That is true. Yes, so answering my Lord's question, yes, we say that is the outcome. That is the absurdity that can arise given the outcome, and therefore we say that couldn't have been intended.
Can I ask you one other question before we go and look
Please,
at the code?
yes.
Your submission to us is that you, as concurrent lessee, are a party to the agreement. The agreement
For the
consisting
purposes of Part 5,
for the purposes of Part
Yes.
5.
we're to be treated as a party to the code agreement for the purposes of Part 5 in order to be able to effect a renewal or a termination.
Is it your submission, or what is your position? Is Gencomp also a party to the agreement?
Well, that is another issue which did not.
It doesn't seem to have been dealt with. But do we
there's
not?
a passing reference to it, my lord, if I may take you to it. It's again, if I may say so, with respect, a very good question, because it's not clear from the code as to how many parties to a single code agreement there are to be. Paragraph 10, as my Lord Justice Lewison has mentioned, paragraph 10 has this automatic.
It treats successor title as parties to the agreement.
Parties to the agreement. And what it says is you're a party to the conferral agreement. So, in this particular case, on the facts of this case, the original grantor was Publico Limited.
Yes.
It then assigned to Cal Management, and then it assigned to a third company, and then it assigned to Gencomp. All those three earlier companies were dissolved, but let us assume that none was dissolved. Let us assume we've had original conferring party together with subsequent assignees. Each, by paragraph 10, is treated as a party to the code agreement. There is nothing in the code that says when their rights are to cease as parties. Now, it could be that one says they've ceased to be parties as soon as they divested themselves of any interest. And there is a passing reference to that in the Deputy President's judgment. If one turns to paragraph 74, that is page 86, my lord, of the core bundle. What he says is, in this case, Publico granted the original agreement to Vodafone, and if it still had its interest in the land, it would be the site provider who is a party to a code agreement. Now, the learned Deputy President didn't elaborate on that, because the issue which your Lordship has raised, the question about who is to be treated as a party to the code agreement, did not need to be debated, although it is an important issue. The learned Deputy President appears to be of the view that once you've disposed of your interest, you've ceased to be a party to a code agreement.
Well, I think that seems to be the purport of the last sentence of that paragraph. where he says the person who currently
Yeah.
answers the description of successor entitled is Gencomp.
Well, there's good sense behind that. We don't disagree. We wouldn't disagree with that as a way forward to try and work the scheme of the code, because otherwise you would have this potential scenario in light of the question raised by my Lord Justice Nugee. You would have this scenario. You could, assuming those previous companies had not been dissolved, you would have four previous companies, all parties to the confer agreement, together with Gencomp. If they are to be treated as a party to the code agreement, what is stopping them serving a termination notice or a renewal notice? But why would they? What's the practical consequence for them? They have no further interest. The original conferring party and the subsequent assignees of that conferring party have no interest in the property. Yet, if they are to be treated as parties to the code agreement, on the face of it, they fit within the words of paragraph 31 and paragraph 33, termination and renewal. It's a matter that your lordships may have to grapple with in coming to a conclusion, because it is an oddity that could be the result. The learned Deputy President in paragraph 74 appears to be of the view that cannot be right. You cannot have those earlier persons being in that position, because one of the important consequences to be aware of, and we'll look at this when we do come to the code, is that under the termination provision is an 18 months notice that can be served 18 months prior to the contractual term. The operator has to take steps to protect itself when it receives a termination notice. If it doesn't, it's out. It has 3 months to serve a counter notice and then 3 months to go to court to protect itself after the service of the counter notice. So if these earlier parties are treated as parties to the code agreement, assuming they haven't been dissolved, one of them serves a notice, the operator forgets about the termination notice, and that does happen. In practice, it is occasionally the case that operators fail to respond to a termination notice because they have so many sites, thousands of sites. In those circumstances, you've had someone up the chain who's supposedly a party to the code agreement terminating it. Then what happens to the current lessee's interest?
But would it be so difficult to read paragraph 10(2)(a) as meaning successors entitled to that interest for the time
For the time being. And that's how the Deputy President read it, and that makes sense. Otherwise, you have this, again, absurdity in the scheme, whereby earlier persons who were treated as parties by paragraph 10 are suddenly able to intermeddle with the interest, albeit they've disposed themselves of whatever legal interest they had in the land. That cannot be right. Deputy President did touch upon that in paragraph 74. That does appear to be a solution.
But that's a slightly different question. As successors to the freehold, I see that point. In your case, Gencomp has not divested itself of all interest in the land. It still retains the freehold.
No, that's right. It hasn't divested itself.
So my question was, is it your case, or do you have a case as to whether Gencomp... I mean, I understand your case that your client is now a party to the agreement. Is Gencomp still a party to the agreement, or
that
is
is
it not,
the,
or do we not need to?
Well, that is the submission of the respondent, that it is and remains a party to the code agreement because it does have the freehold. It is also its case that it can serve a termination notice under paragraph 31. We submit that's incorrect. We submit that's incorrect both from a practical position and in respect of a legal position, because if Gencomp were to terminate the conferral agreement that exists between it and Vodafone, if it were able to do that, you would have, again, a termination of the underlying contract that has given rise to the estate in land, terminated by someone up the chain. APW is the concurrent lessee, Vodafone is its lessee. Gencomp serves the notice on Vodafone to terminate. Again, let us assume Vodafone do not react. That terminates the continuing contract under paragraph 30, contract out of which the estate in land has arisen, that destroys APW's leasehold interest vis-à-vis Vodafone. That cannot be right. It just doesn't
Well,
work.
it might be a breach of
Well, could be,
some obligation owed by Gencomp
it's
to
definitely
you.
derogation from grant.
Yes.
But equally, as a stranger to the leasehold arrangement, we say that could not work.
Well,
But it's not a stranger. I mean, this is the
It's not a
this is
stranger.
what lies behind my question.
Yes.
Gencomp is not a stranger to the leasehold. It granted the leasehold interest to Vodafone in the first place, and the effect of the 95 Act. We'll come to this in due course, but just so I'm clear as to where we're going, is that although the benefit of the covenants in the lease and the burden of the covenants in the lease have passed to you, it still retains the benefit of the covenants, and there can be real
That is
cases where it wants the benefit of the covenant, that it wants to be able to enforce it.
that is the respondent's contention. On the facts of this case, it's difficult to see.
except you told us it's not about the facts of this
Well,
case.
Well,
that's right. I'm saying it's not. I accept that, my lord. Just that's why I say, from a practical and a legal point of view, from a practical point of view, in this particular case, we say that there's no need for them. It's difficult to envisage the circumstances in which they could terminate. Perhaps you can elaborate on that.
But it's
when
not
we come to
just
paragraph 31.
termination. I mean, you're concentrating on termination, but the covenants, Vodafone's covenants in the lease, are primarily not about termination. They're about complying with obligations. I mean, suppose, for example, one of its bits of equipment caught fire and destroyed the tower. The reversioner would have a claim against Vodafone. So the freeholder does.
Well, that may be a tortious claim.
Well, it might be a tortious claim, but it might well be a breach of covenant. My point is that under the 95 Act, you can't equate Gencomp as a freeholder who's parted with all possession, with all interest in the property.
I would accept that. It's not.
So I'll go back to the question: is Gencomp, in your submission, a party to the code agreement or not? Or is it not something you have a position on? Because there seems to be there's a difference.
Yes.
There may be a difference between you being the only party to the agreement, other than the operator, and both you and Gencomp being parties to the agreement.
My case can succeed even if both Gencomp and myself are treated as part of the code agreement. This court does not have to make a decision as to whether or not Gencomp is or is not a party. That may be another case for another day if Gencomp or someone in its position as a superior landlord in another case were to seek to terminate the underlying code agreement and with a concurrent lessee in situ. But my submission is, I would, if that case were to arise and we were having to argue that today, I would say from a practical position, it would be difficult to see how Gencomp would have any interest. But I hear what your lordship says. But
Well, you told us that you've got to give 18 months' notice.
give 18 months
So
notice.
if-
Well, that's for
if-
termination, my lord.
Right.
And
So if the concurrent lessee's interest were to expire 6 months in 6 months' time, the person higher up the chain could have a very real interest in terminating the underlying contract.
yes, you could. I could see that. That's not an issue that arises for today. I would accept that for purposes of today, it does not undermine my position for Gencomp to be a party. Because my submission essentially is, if and insofar as they are to be treated as party, they're not the only party.
Yeah.
I too am to be treated as a party. Thank you. So we've been debating the code a bit, but I would still, if I may, just run through the code provisions so we can see what it is we're talking about, and it may be that other matters come to your lordships as we go through the code. I shall try and go through it as quickly as possible. It's tab 21 of bundle 2.
Starts page 414.
Thank you, my lord. I do apologise. Thank you. 414. Thank you. So, as a preliminary, just to mention this, of course, code came into force on the 28th of December 2017. It protects operators. Operators are those with respect to whom the code has been applied by a direction under Section 106 of the Communications Act 2003. That is, there's no dispute in this case that Vodafone is an operator within the meaning of the code. There is also, given that the interest of Vodafone was created prior to the new code coming into force, its interest was created in 2003. Again, there is no dispute that under the terms of the transitional provisions of the code, Vodafone's interest is to be treated as a subsisting agreement, and therefore it is to be treated as a code agreement. And moreover, because the Vodafone agreement was contracted out of the provisions of Part 2 of the Landlord and Tenant Act 1954, which confers, as you know, security of tenure on business tenants, again, by the transitional provisions, it was protected by Part 5 of the code. Thus, any renewal or termination of it was to be in accordance with Part 5. That's paragraph 6 of Schedule 2 to the Digital Economy Act 2017. That's in the bundle. I'm not sure we need to look at it. There's no dispute about that. So, looking at the code, let's start off with paragraph 1. We have various, in subparagraph 2, various definitions. Go to 105 for occupier, general interpretation of 108. And then paragraph 2 defines who an operator is in subparagraph A, where this code is applied by a direction under 106. And in paragraph 3, we have the code rights. This extract, it reflects the very recent amendments of the Product Security and Telecommunications Infrastructure Act 2022. It doesn't impact on the courts, on the matter that is before the court today. There were 9 code rights, there are now 12. And for the purposes, paragraph 3 says, for the purposes of this code, a code right in relation to an operator and any land is a right for the statutory purposes in respect of that menu of rights. And the code and the statutory purposes is then to be found in paragraph 4.
Can I just ask one question about paragraph 3?
Yes, my lord.
If you are in the position of Gencomp and you purport to grant a right which cannot be exercised, is it a code right at all?
The Deputy President said they were unable to do that. That was Deputy President's conclusion, because...
Well, he said because they were occupiers, but, I mean, could they grant a code right at all? It can't be exercised.
The only... that was the point raised in Compton Beecham, wasn't it? That because they're not the occupier, they're incapable of conferring what is a code right, because paragraph 9 tells us...
Well, I think that was because of paragraph 9. I was really asking about paragraph 3.
Yes.
The definition of code right mean that if it can't be exercised, it can't be a code right.
Because it cannot be exercised against them. All it can be is exercised against APW.
May not matter. Right. You wanted us to go to...
yes, just to we can see the statutory purposes. So the code right has to be one in relation to an operator or any land for the statutory purposes. The statutory purposes are then defined. Just to note that, and then the definition of electronic communications apparatus is to be noted in paragraph 5. And then we have conferral under part 2, which is page 417. And we have this approach to the statute where we have an introductory paragraph setting out what this part is intended to be about. Then we have paragraph 9, which was the subject of debate in the Compton Beecham case. Code right in respect of land may only be conferred on an operator by an agreement between the occupier of the land and the operator. And then paragraph 10 is who else is bound by code rights. And for the moment, I'll just touch upon what it's saying. obviously, your lordships have read it, but we have this requirement that it provides for the person who is conferring it's required to have an interest in land when the code right is conferred. And in those circumstances, we have this binding quality. And subparagraph 2 says it binds successors entitled to that interest. And then a person with an interest in the land that is created after the right is conferred and is derived directly or indirectly out of O's interest or the interest of a successor, and also any other person at any time in occupation of the land whose right 2 occupation was granted by O at a time when O was bound by the right, or a person within A and B. And then a successor in title who is bound by a code right by virtue of 2A, i.e. successor entitled to that interest, is to be treated as a party to the agreement by which O conferred the right. The code right also binds any other person with an interest in the land who has, pursuant to an agreement under this part, agreed to be bound by it. So that's a binding, a specific agreement by which you are agreeing to be bound by it. If such a person, P, agrees to be bound by the code right also binds, and then it says its successors, and it replicates the earlier position in relation to the conferrer. And then subparagraph 6 says a successor in title who is bound by a code right by virtue of 5A is to be treated as a party to the agreement by which P agreed to be bound by the right. And that's paragraph 10. And then we have requirements for agreement in paragraph 11. These are mandatory requirements in order to have a code agreement. Must be in writing.
Just let's pause a moment on 10.4.
Yes.
10.4 seems to be... Oh no. 10.4 is introduced, is it, by 10.1? This paragraph applies.
Yes.
Oh, wait a minute.
So
Yeah,
paragraph
I
is
see.
applied.
So paragraph 1 applies generally. Subparagraph 2 applies only where O has an interest in the land.
Yes.
That does not appear to be a condition of 10.4. So if the grazing licensee grants the operator the right to put up a mast,
That's
the freeholder could agree under 10.4 to be bound. Is that right?
That is right. And if not,
But on the basis of the Upper Tribunal's reasoning, would not be a party to the agreement because it doesn't fall within 5A, because it's not a successor entitled to the grazing licensee, and would not, on that reasoning, be entitled to terminate. Right?
if you are the original party who is agreed to be bound by it,
Does that make you a party to the
it's
agreement?
not, well, one would assume, in order for the code to work, that you would expect the original binding party, the binder, to be capable of terminating it. Again, it would be an oddity if the person who agrees to be bound cannot then seek either to renew it or to terminate it.
Well, on day 1, the grazing licensee and the operator enter into an agreement. And on day 200, they approach the freeholder and say, the grazing license is about to expire, would you agree to be bound by this agreement? And the freeholder says, yes, all right, I will be.
Yes.
Is he party to the agreement?
Well, I would have thought that he is, because subparagraph 6 says a successor in title is bound by a code right by virtue of sub 5A is to be treated as a party to the code.
Yes, but the freeholder is not a successor
Well,
to the grazing licensee.
No, that is true. He's not a successor to the grazing licensee. That is true. Yeah.
The party who agrees
Yeah.
to be bound by the code right may only agree that with the operator.
Yes.
They
That
may
is
not
so.
agree. They may not agree with
Yeah.
the party
No,
granting
the
the right.
party up the chain will not be a successor because he's got a superior interest. He's not a successor to someone with the inferior interest. I accept that. Yes. That's the example I've given in our skeleton about the surrender, where the tenant surrendering, the freeholder is not a successor to the tenant's interest.
It's clear from 10 to paragraph 3 that a party can be bound but not be a party to the agreement.
My lord, you're saying someone can be bound but not a party. As from paragraph.
Yes, you can be
subparagraph
bound by the code right, but that doesn't make you party to the agreement by which it was conferred.
If you're a successor, then you are treated as being bound. That is so.
Yes.
But you can be bound in other ways, which is what subparagraph 4 is dealing with. And of course, we would submit that in relation to a landlord and tenant arrangement, you're bound by the arrangement anyway as a matter of property law, irrespective of what paragraph 10 says. This comes back to well, this gives rise to what's the purpose of paragraph 10. And you've seen from our skeleton that we say that what paragraph 10 was seeking to deal with was to ensure that the burden of contractual arrangements was binding on successors. It didn't need to deal with leases, because as the Law Commission itself said, leases look after themselves. But that's the purpose.
Can I pick up my Lord's point?
Yes.
Before you get to 10.4, just looking at 10.2 and 10.3. 10.2 gives you three categories of people who were not the original parties to the conferring of the code right, but are nevertheless bound by it.
Yes.
A, as successors entitled to owes interest, and then when you look at 10.3, they are treated as parties to the agreement. But the other two categories, that's those with derivative interests in land, that's little b, and anybody else who's been granted a right of occupation, presumably licensees who don't have an interest in land, that's little c, are not within 3.
Or not.
So, just looking at 10.2 and 10.3, it does draw a distinction between the class of people who are bound by a code right, which includes but extends beyond successors entitled, and the class of people who are treated as parties to the agreement,
Yes.
which is only expressly successors entitled. So, it does mean there are people who are bound by the agreement, those in 10.2b and 10.2c, who are not, at any rate not expressly, treated as parties to the
Who are
agreement.
not. As you say, there are parties who are not treated. Sorry, there are persons who are not treated as parties. That is absolutely right.
What is the purpose of that?
Well-
'Cause I don't think I've quite understood
Uh,
what. This is obviously a crucial distinction between
Yes, I mean-
being bound by a code right and being treated as a party to the agreement by which the code
Well,
right is conferred.
the-
What's the
the-
difference?
The issue with respect to being bound is, of course, that those that are not being treated as parties are persons whose interests are created after the conferral agreement has been effected. If you go back to 10.2b,
Yes.
this person is not a person who's going to be treated as a party. And the reason for that is he's a person with an interest in land that's created after the right is conferred and is derived directly or indirectly out of those interests or the interest of a successor to those interests. So that derivative interest that comes later is not being treated as a party. And also anyone else who's in occupation, whose right to occupation was granted by O at a time when O was bound by the code right. So clearly, those persons who who are simply in occupation are not going to be treated as parties, because otherwise there's going to be too many people that can intermeddle with the code agreement. And why should they? They haven't conferred it. And they're not going to be treated as parties to the conferral agreement. And that exclusion of those derivative interests and those occupiers makes sense. But what paragraph 10 doesn't say is that you are treated as a party if and only if. It doesn't say that. And there may be other circumstances where it would be appropriate for this court to say that you are a party to a code agreement for the purposes of Part 5, namely where you're a concurrent lessee. Now, it is the case that a concurrent lessee could be said to derive its title from the superior landlord, in which case, and this is the respondent's case, on that distinction that your lordship has drawn or identified, we clearly must not be a party to the code agreement. Paragraph 10, it is being said, is completely exhaustive of the circumstances in which you would be treated as party. Anyone outside paragraph 10 can never be a party. Now, we'll look at paragraph or part 5 in a moment, but paragraph 10 doesn't say you're only treated as a party in these circumstances. It doesn't say that. Where the draftsman wanted to be emphatic, if and only if, He's used that on 4 or 5 occasions. Doesn't use it here. And secondly, part 5, when it talks about being a party to a code agreement, doesn't refer back to paragraph 10. It doesn't say that you're a party to a code agreement, for instance, in accordance with paragraph 10. It doesn't say that.
No, I think my question was a more basic one, which is just looking at 10.2 and 10.3. I have your point. On your case, these aren't exhaustive and so on. And you say, well, I think you say 2 things. I think you say, A, I am a successor in title, properly understood, if necessary. But B, you say, quite apart from paragraph 10, I'm to be treated as a party to the agreement. If I've understood it, those are your alternatives.
My primary case is the latter.
Yes.
My secondary position is the first.
But before you get to that question, in other words, who's right on the appeal, what is it that the code means when it draws the distinction, as it so clearly does, between someone who's bound by a code right and someone who's party to the agreement? What's the practical consequence of, on the one hand, being bound by a code right, and on the other hand, being party to the agreement conferring it?
That is, in trying to answer that question, all I can point to is that the being bound is clearly intended to ensure that a mere contractual right, where the operator's interest is purely contractual, the grantor, who has a legal interest in land, when it assigns, that contractual arrangement would be binding. Now, it is true that it could be said, well, that's immaterial because the successor entitled to that interest is to be treated as a party. It may be that to be bound is having some other statutory consequence, but isn't as effective as being treated as a party to the code agreement. What that difference is, I mean, is it the benefit of the covenants? You're bound, so you have the burden, you don't have the benefit?
Well, don't ask me.
Well, I know, I'm saying rhetorically, I'm not asking you, I'm just sort of thinking aloud that being bound, there is perhaps some, certainly in the earlier legislation under the old code, the provision about being bound was elaborated upon, which doesn't appear to be replicated in the new code. Perhaps if I could just turn to that. It's in the old code, which we'll find at tab 17, page 365.
This is the landlord tenant. Oh no, sorry.
No, this is the old code,
Yeah,
my
yeah,
lord. This is the code that existed
Yes.
prior to the new code coming into force. So and then 2.5, the paragraph 2 I should say is paragraph 2 is dealing with the circumstances in which various parties are to be treated as being bound, and then it says a right falling within subparagraph 1 above shall not be exercised except in accordance with the terms, whether as to payment or otherwise, subject to which it's conferred, and according every person for the time being bound by such a right shall have the benefit of those terms. So it would appear that accordingly, being bound gave you the benefit. That appears to be what the drafter was thinking there, that, and accordingly every person for the time being bound shall have the benefit. Now, in the new code, paragraph 2, subparagraph 5 does not appear to be replicated in its entirety. We have paragraph 12, subparagraph 1, page 419. Where it refers to a code right is exercised only in accordance with the terms subject to which it is conferred. It doesn't appear to then go on to say, and accordingly, you have the benefit. All it seems to say is you're bound, but perhaps the drafter of the new code thought it was unnecessary to have those additional words because and accordingly was what was then followed was necessarily implicit in being bound. But trying to answer my Lord Justice Nugee's question about the distinction that we see in paragraph 10 between being bound and being a party, what is the essence, what is the essential difference between being a party and being bound? If it is the case that being bound gives you both the benefit and the burden of covenants, then there may not be much of a distinction. But clearly the drafter thought there was.
Just go back to 10.4 for a moment, because I'm still quite puzzled by it. You've got somebody with a shortish lease who is approached by the operator and is given the right to install some kit on top of the building, let's suppose. And the operator wants a term which is longer than the lessee has. So you go up the chain and ask the freeholder, will you agree to be bound by this agreement? Freeholder says, yes, let's suppose. 10.4 doesn't say the freeholder is a party to the agreement. Now, put it the other way around, freeholder says no. So the operator goes on to paragraph 20, asking for the freeholder to be bound by the agreement that he's reached with the lessee. Tribunal says yes. Isn't the effect of paragraph 22 that there is now deemed to be an agreement between the operator and the freeholder, to which presumably the freeholder was a party?
I would accept that.
So there seems to be a bit of a mismatch between one reading of 10.4 and the effect of an order from the tribunal.
Yes. But there does, on the face of it, given the example, I would accept the analysis. But I only query the question of the original party not being a party to the binding agreement, given what paragraph 6 says. But as your lordship says, he's not a successor.
Right.
So you cannot sort of, as it were, square the circle.
Just going back to the 10.2, 10.3 point. The way it strikes me is that what it has in mind is that the occupier who has an interest and has conferred the rights, or his successor in title, remains the party to the agreement thereafter, and has the rights under Part 5.
Yes.
Anyone else who has an interest which is conferred or derived from that interest or the successor's interest is not the party with the rights, but the party remains the occupier or their successor. But that party cannot challenge the rights, cannot assert a greater or competing interest
The person
by virtue of.
Yes, I would accept that down the chain. Yes, that's right.
So I'm not sure why that's particularly difficult.
Why that distinction was thought necessary? All I can suggest is that it was considered inappropriate for those with inferior interests and those who don't even have an interest in land, such as those who were simply in occupation, to be able to be said to be a party, so as to, as it were, intermeddle. They are bound. That is what is said. So they cannot seek, for instance, an injunction for removal. They cannot seek to exercise Part 6 rights, particularly with those with derivative interests. Part 6 is dealing with how you remove electronic communications apparatus. You have to have an interest in land. So persons with a derivative interest in land, they are bound, but they're not a party. Those who are simply occupiers are bound, but they're not a party. I assume the policy is simply to reduce the number of persons that can intermeddle with the agreement. But it doesn't undermine, with my respectful submission, the case we're presenting on who's a party to the code agreement. So if I may, we'll come back to paragraph 10. If I may just...
Yeah.
We was looking at requirements. We've dealt with that paragraph 11. Paragraph 12 was the code right exercised in accordance with terms subject to which it is conferred. And then we have paragraph 14, where an enactment requires interest charges or other obligations affecting land to be registered. The provisions of this code about who is to be bound by a code right have effect whether or not that right is registered. So it matters not that a leasehold interest may not be registered under the Land Registration Act. Those interests, unregistered interests, are still have a binding quality. Then part 3, which deals with assignments. Paragraph 16 provides for an unconditional entitlement on the part of the operator to assign the code agreement. Any agreement under Part 2 is void to the extent that it prevents or limits assignment of the agreement to another operator, or it makes assignment of the agreement to another operator subject to conditions, including a condition requiring the payment of money. And then subparagraph 2, subparagraph 1 does not apply to a term that requires the assignor to enter into a guarantee agreement. See subparagraph 7. And then, from the time when the assignment of an agreement under Part 2 of this code takes effect, the assignee is bound by the terms of the agreement. The assignor is not liable for any breach of a term of the agreement that occurs after the assignment, if and only if, before the breach took place, the assignor or the assignee gave a notice in writing to the other party to the agreement, which A, identified the assignee, and B, provided an address for service for the assignee. And then subparagraph 5 is subject to the terms of any guarantee agreement. And then we have a guarantee agreement, a sort of ARGO. So there are 2 points to note just in passing. The first is in relation to paragraph 16(4). From the time when the assignment of an agreement under Part 2 of this code takes effect, the assignee is bound by the terms of the agreement. So we come back, my lord, to the question of being bound. Note, there is nothing in the code, not in this paragraph or anywhere else in the code, that says that an assignee operator is to be treated as a party to the code agreement. Now, my learned friend and I are at idem on this, in that it cannot have been contemplated that assignee operators could not seek to renew the code agreement which they have taken an assignment of. It could not be the case that the original operator only, being a party, has to seek renewal. All that 16(4) does is to make that assignee, from the date of the assignment, to be bound by the terms of the agreement. So just please note that. And then one of the points that we make in subparagraph 5 is that one has to give notice in order to relieve yourself of liability. One has to give notice in writing to the other party to the agreement in subparagraph 5. You see that. And one of the points we make is, well, on the arrangement that we have where there's a concurrent lessee, the notification has to be given to the superior interest.
But the operator doesn't have to be party to an agreement, does he, before he can ask for renewal? All he's got to do is be an operator.
No, with respect, I do not agree with that. Well, then let's look at paragraph 33. I mean, it may be that I'm reading it differently to your lordship.
I read it, I mean, I can perhaps see how you read it. I read it as A,
an operator,
or B, a site provider who is a party to a code agreement.
I must say, I've always read it as meaning an operator or site provider who is a party to a code agreement. Either of whom.
Rather, yeah.
Right.
Yes, that wasn't how I read it, but I see you can read it that way. But in paragraph 20, for instance, simply applies where the operator requires somebody to confer an agreement. Doesn't say anything about being a party to the code agreement.
I'm sorry, my lord, I apologise.
Paragraph 20, for instance, just talks about the operator requiring conferring agreements to be bound. Doesn't say anything about.
No, it doesn't. It doesn't. But it wouldn't want to. It doesn't need to say anything in the context of paragraph 20, because all you have to be is an operator.
Yeah.
There's nothing required there.
All right, you've got as far as paragraph 16.
Yes, I did. Yes, sorry, my lord, just on one point, on paragraph 33, just if we may, we'll look at this in a moment, but just whilst it's on my mind, if one goes back to termination and paragraph 31, the site, does your lordship have that? It's page 436,
Yes, I see.
paragraph 31.
Yeah.
Site provides a party to a code agreement may bring the agreement to an end by giving notice in accordance with the paragraph to the operator, who is a party to the agreement. Yeah. Yes, sorry, my lord. Where was I? I was at paragraph 16 and 17. Sorry. Yes. 17 we have.
So you would say that paragraph 31 assumes that an assignee is a party
yeah.
to the agreement,
Yeah.
even though paragraph 16 doesn't say so.
Doesn't say so. That's right. So the assumption within the code is that an assignee operator taking an assignment to the code agreement is a party to that code agreement. Yes, so paragraph 17 is power to upgrade or share. And then we have various conditions. Subparagraph 2 deals with the first condition, which mustn't have any adverse impact or no more than a minimal adverse impact on its appearance. And that's been held by Upper Tribunal decisions to be the appearance of the electronic communications apparatus itself. And then the second condition is that the upgrading or sharing imposes no additional burden on the other party to the agreement. And we say, given the person that is most directly going to be affected by the any upgrade or any sharing is going to be APW. It would be odd to think that paragraph 17 could operate only by reference to someone further up the chain. Then moving on to part 4, paragraph 19, we have the introductory provision as to what it's dealing with. Paragraph 20, I'm not sure we need to spend any time on. It's just the circumstances, as your lordship's pointed out, as to who can seek code rights. And then we have the test in paragraph 21, which is various conditions. Paragraph 2, first condition is prejudice caused to the relevant person is capable of being adequately compensated by money. Second condition is public benefit likely to result from the making of the order outweighs the prejudice to the relevant person. And then deciding whether the second condition is met, the court must have regard to the public interest in access to a choice of high-quality electronic communication services. The court may not make an order under paragraph 20 if it thinks that the relevant person intends to develop all or part of land to which the code right would relate, or any neighbouring land, and could not reasonably do so if the order were made. So there's an ability to resist imposition if you're going to redevelop. And in practice, that is utilising the principal ground on which resistance is made. Very, very, very difficult for a site provider to resist under the first or second condition. There's only been one reported case where the second condition hasn't been fulfilled.
So what does the tribunal do if the operator says, I want a 10-year agreement, and the landowner says, well, I want to redevelop in 5 years' time?
Then the tribunal has, in reported cases, incorporated a redevelopment break clause. They have indicated that, as with the 1954 Act, the code should not be seen to inhibit or prohibit redevelopment. So break clauses have been incorporated. And by reference to the case law that one sees under the 54 Act. As a sort of, then paragraph 22, your lordship's already referred to, which is it takes effect. An order under paragraph 20 takes effect as a Part 2 agreement. And then paragraph 23 tells you what the tribunal is going to have regard to. I'm not sure we need to spend any time on the detail of that at the moment, but just to note that's the, as it were, matters that are to be taken into account. Then consideration under paragraph 24, which is caused the problems that have existed in a number of cases because of the formula to disregard the use for telecommunications, electronic communications use, but that's the formula. And then compensation provisions in 25, interim code rights in 26 and temporary rights in 27 need not detain us. Part 4A we need not look at, that's something that's come in, the game does not affect this case, nor any of the arguments on this case. And then we get to part 5, and then paragraph 29. This part of this code makes provision about, and it says continuation of code rights after they cease to be exercised, or procedure for bringing agreement to an end, procedure for changing agreement relating to code rights, arrangements for the making of payments, etc. An application, 29, this part of this code applies to an agreement under part 2, subject to subparagraphs 2 to 4. This part of this code does not apply to a lease of land in England and Wales if its primary purpose is not to grant code rights, and it's a lease to which part 2 of the 54 Act applies. In determining whether a lease is one to which part 2 of the 54 Act applies, any agreement under section 38A is to be disregarded. An agreement to which this part of this code applies is referred to in this code as a code agreement. Now, again, whilst we're looking at the provision, another point to note is that if one it's an agreement where the primary purpose is not to grant code rights, but you're a quasi-code agreement, as it were. You have some code rights, but your primary purpose is not to grant code rights. And you're within the 54 Act. Then you're not within Part 5. But then the 54 Act is not a problem for a concurrent lessee. So with quasi-code rights, where the primary purpose is not to grant code rights.
Well, you mean ancillary, I think.
Ancillary, yes, ancillary. Where it's ancillary, the concurrent lessee scenario is not a problem. Then we have continuation under paragraph 30. Subparagraph 2 applies. So subparagraph 2 applies if a code right is conferred by or is otherwise binding on a person, the site provider, as the result of a code agreement. And under the terms of the agreement, the right ceases to be exercisable, or the site provider ceases to be bound by it, or the site provider may bring the code agreement to an end, so far as it relates to that right. Where this subparagraph applies, the code agreement continues so that the operator may continue to exercise that right, and the site provider continues to be bound by the right. Note, it's a continuation of the code agreement. Then we don't need to worry about subparagraph 3 because that disapplies the continuation provisions in relation to paragraph 26 and paragraph 27. And then subparagraph 2 is subject to the following provisions of this code. 31.1. Site provider who is a party to a code agreement may bring the agreement to an end by giving notice in accordance with this paragraph to the operator who is a party to the agreement. Then there are various requirements as to what the notice must do. And then the date in subparagraph 3, the date to be specified, must fall after the end of 18 months, beginning with the day on which the notice is given, and after the time at which, apart from paragraph 30, the code right to which the agreement relates would have ceased to be exercisable or bind the site provider, or at a time when, apart from that paragraph, the code agreement could have been brought to an end by the site provider, for instance, a break clause. And then grounds. So these are the grounds that you have to rely on in order to terminate. The grounds stated under subparagraph 2c must be one of the following. A, that the code agreement ought to come to an end as a result of substantial breaches by the operator of its obligations under the agreement. B, that the code agreement ought to come to an end because of persistent delays by the operator in making payments to the site provider under the agreement. C, that the site provider intends to redevelop all or part of the land to which the code agreement relates or any neighbouring land and could not reasonably do so unless the code agreement comes to an end. We say the person most likely to be concerned with those particular grounds of termination would be in the context of our scenario, the current concurrent lessee. D, that the operator is not entitled to the code agreement because the test under paragraph 21 for the imposition of the agreement on the site provider is not met. And of course, the imposition under paragraph 21 is for conferral in relation to exercise of code rights. And again, we would say that the concurrent lessee is the person that's most likely to want to be able to resist under that particular test. Because the test is about whether or not you have regard to the public benefit in having access to a choice of high quality communication services. And then the effect of the notice under paragraph 31. Paragraph 32, where a site provider gives a notice under paragraph 31, the code agreement to which it relates comes to an end in accordance with the notice unless. So,
I'm not quite sure I've understood 4D.
4D, yes.
He's not entitled to the code agreement.
Yes, I believe
He has a code. He's got a code.
He's got a code agreement, but it's an unusual form of termination provision. What it appears to contemplate is that the site provider is able to say, you do have a code agreement, but if you were to apply under paragraph 20 today, you would not satisfy the paragraph 21 test.
Well, I see why that ought to be what it says, but it's difficult to see how it does say that.
Well, fortunately, I'm not sure we have that case before us today.
You really need to read "is not entitled to" as "should not be entitled to keep."
Should not be entitled to, yes. Yes, should not be entitled to, notwithstanding the fact you have one.
Yes.
Yes, I mean, it only helps to this extent that the code is not a model of draftsman's clarity.
No. Wasn't that said in Bridgewater by your lordship in relation to the old code?
Yes, I may have to revise my view.
So paragraph 32. We have, where a site provider gives a notice on paragraph 31, the code agreement to which it relates comes to an end unless. So that's why I said when I was answering a question from my Lord Justice Nugee that about the absurdity of the situation, the operator does have to take action, otherwise his code agreement will come to an end, unless A, within the period of 3 months, beginning with the day on which notice is given, the operator gives the site provider a counter notice in accordance with subparagraph 3, and within the period of 3 months beginning with the day on which the counter notice is given, the operator applies to the court for an order under paragraph 34. So there's 3 months of counter notice and then 3 months to issue after service of the counter notice. And then subparagraph 1 does not apply if the operator and the site provider agree to the continuation of the agreement, of the code agreement. What that actually means is unclear, but again, I'm not sure we need to bother too much today about the meaning of agree to the continuation of the code agreement and its implications. But that's what it says. And then subparagraph 3, the counter notice must state that the operator does not, and this is really the content of the counter notice. Again, I'm not sure we need to spend too much time on that, other than that the operator wants, in C, that the operator wants the site provider to agree or confer, otherwise be bound by a new code right of the existing, in place of the existing code right. So various things that you have to put in. If on an application under 1B, the court decides that the site provider has established any of the grounds stated under paragraph 31, the court must order that the code agreement comes to an end in accordance with the order. Otherwise, the court must make one of the orders specified in paragraph 34. Then 33 deals with renewal. 33.1, an operator or site provider is a party to a code agreement by which a code right is conferred by or otherwise binds the site provider may, by notice in accordance with this paragraph, require the other party to the agreement to agree that. Perhaps reading it again, perhaps that answers the point your lordship.
Yes, it may do, because
it says the other party to the agreement.
Yeah.
That A, the code agreement should have effect with modified terms. B, where under the code agreement more than one code right is conferred by or otherwise binds the site provider, the agreement should no longer provide for an existing code right to be conferred or otherwise bind the site provider. C, the code agreement should confer an additional code right on the operator, or provide that the site provider is otherwise bound by an additional code right, or the existing code agreement should be terminated and a new agreement should have effect between the parties. So A is modification, B is where is a removal of a code right. I've never encountered that, but it's very unusual. And then C is additional, conferring additional code rights, and D is a completely new agreement, termination followed by new agreement. And then we have what the notice must do in subparagraph 2. That's various statutory requirements. Again, we don't really need to deal with that. And then subparagraph 3 again deals with the notice, the date to be specified. And in this particular case, it's at the end, it must fall after the end of 6 months, beginning with the day on which the notice is given. So this is a 6-month notice. After the time at which, and after the time at which, apart from paragraph 30, the code right to which the existing code agreement relates would have ceased to be exercisable, or to bind the site provider, or at a time when, apart from that paragraph, the code agreement could have been brought to an end by the site provider. Then 4, subparagraph 5 applies if, after the end of the period of 6 months, beginning with the day on which the notice is given, the operator and the site provider have not reached agreement on the proposals in the notice. So the gateway to making an application is absence of agreement. 5, where this paragraph applies, the operator or the site provider may apply to the court, for the court to make an order under paragraph 34. Then paragraph 34 tells us what orders can be made. And then we have various orders, subparagraph 2. So, just apologies, subparagraph 1 just needs to make a note that 32(1)(b), of course, is in relation to the termination. So where an application is made, we pick that up from 32(5). Otherwise, the court must make one of the orders in paragraph 34. So 34 applies where the site provider fails in its termination or in relation to renewal. So, yes, so the subparagraph 2 may continue to exercise the code rights in accordance with the existing code agreement, so it's just allowed to continue for such period as the tribunal orders. Order modification, and then order provision for the removal of the code agreement in subparagraph, the code right, in subparagraph 4. The code right ceases, no longer provides for an existing code right. Then subparagraph 5, modification conferring additional code rights. And subparagraph 6 is the court may order termination of the code agreement relating to the existing code right, and an order that the operator and the site provider enter into a new agreement which confers a code right on the operator or provides for a code right to bind the site provider. Existing agreement continues until the new agreement takes effect. This code applies to the agreement as if it were an agreement under Part 2 of this code. Terms conferring or providing for an additional code right under subparagraph 5 and the terms of the new agreement under subparagraph 6 are to be such terms as agreed between the operator and the site provider. If the operator and the site provider are unable to agree on the terms, the court must, on the application by either party, make an order specifying those terms. 11, paragraphs 23, 2 to 8, which deals with the terms for imposition under Part 4. 24, which is consideration, 25 and 84, which deal with compensation, apply to an order under subparagraphs 3, 4, or 5, insofar as it modifies or specifies the terms of the agreement, and to an order under subparagraph 10. It's rather convoluted drafting because we know when we go back to subparagraph 10, the subparagraph 10 is operating in relation to subparagraphs 5 and 6. So in fact, the effect of subparagraph 11 is to apply the provisions of paragraphs 23, 2 to 8, 24, 25 and 84 in respect of a claim for termination and a completely new agreement. And that's a product of subparagraphs 9 and 10 and then 11b. It's very convoluted drafting, but that's the impact. So. And then 12 says, in the case of an order under subparagraph 10, the court must have regard to the terms of the existing code agreement. So that's in respect of additional code rights or a new agreement. The court must have regard to the terms of the existing code agreement. And then in determining which order to make, the court must have regard to all the circumstances, and in particular, A, the operator's business and technical needs, the use that the site provider is making of the land to which the existing code agreement relates, any duties imposed on the site provider by an enactment, and the amount of consideration payable by the operator to the site provider under the existing code agreement. And then 14 and 15 deal with what one can describe as some sort of interim rent equivalent to the 54 Act. We don't need to look at that. Ditto 35. And then Part 6 of the code at page 441 is, just to note more than anything, the provisions for removal. 37 subparagraph 1. A person with an interest in land, a landowner, has the right to require the removal of electronic communications apparatus on, under or over the land, if and only if one or more of the following conditions are met. And then there's various conditions that are set out. So the right to seek removal is conferred simply on a landowner as long as it satisfies one of those, I think there's 5 conditions. Again, the terms of which we don't need to spend any time on at present. So in relation to the other provisions that I wanted to touch upon, we have paragraph 100, which is at page 450. Paragraph 100 says, this code does not affect any rights or liabilities arising under an agreement to which an operator is a party. Subparagraph 1 does not apply in relation to paragraph 99 or parts 3 to 6 of this code. And this is commonly understood as an anti-avoidance provision with respect to parts 3 to 6 of the code. So you cannot, as it were, contract out of part 5. And then over the page 450A, there's the meaning of occupy in case we need to look at it. As I say, I think it's accepted from my learned friend that APW is the occupier for the purposes of conferring code rights in accordance with the Compton-Beecham decision. And then page 450C is the definitions provision of 108. So we have various definitions. We have amongst them the code agreement. C has the meaning given by 29.5. And then we have landowner, has the meaning given by 37.1. And then we also have relevant person, has the meaning given by 20, subparagraph 1. And we have site provider, has the meaning given by 30, subparagraph 1. What we don't have is a party to a code agreement. It didn't seem to be a matter that the drafter thought was worthy of incorporating as a definition. So that is, those are the provisions of the code that I would wish to refer to. If I may move on then to the substantive part of the submission. Obviously, we've been making various points going through the code, but why should Part 5 be available to the concurrent lessee? The Deputy President identified the various things that can be done between APW and Vodafone as a matter of landlord and tenant. And we analysed that position at paragraphs 21 to 22 of our skeleton as to what we can do vis-à-vis Vodafone. I'm not sure I need to go through that. It's there in the skeleton. It's accepted, I believe, by my learned friend. The only point that's possibly not necessarily at issue between us, but it's a point that my Lord Justice Nugee mentioned in the context of the Landlord and Tenant Covenants Act 1995. It is accepted that we can enforce the covenants under Section 15 of the Landlord and Tenant Covenants Act. It's also the case that it would appear that the reversioner, not only the immediate reversioner, but the reversioner, i.e. Gencomp, could also enforce those covenants. But I've answered that as to whether or not that's material I don't need to say anything further on that. So, subject to anything your lordships were wishing to ask me about landlord and tenant, I would invite you just to read the Deputy President's judgment and my skeleton, our skeleton, at 21 to 22. As I say, subject to the slight nuance on the 1995 Act, I think it's agreed. And equally, the code analysis, what we, APW, and Vodafone can do as a matter under the code. Again, that is contained in our skeleton at paragraph 22, and the Deputy President sets that out. But it is right to emphasise that we are the only party that can voluntarily do anything under the code. We are the only party, in accordance with Compton Beecham, that can confer rights upon Vodafone, because we are the occupier, in accordance with the terms of paragraph 105. You tune out, as it were, the operator's occupation. So we can confer new code rights, we can confer additional code rights, and we can modify code rights, all voluntarily. But as soon as the contractual term comes to an end, what we cannot do is then renew. We're then out of the picture. We ended up in a position where, because we didn't do it voluntarily, we're stuck. We're not able to do it unless the operator agrees. So that's the position under the code. So again, unless there's anything in particular that your lordships wanted to ask me about that. And I emphasised earlier, in answer to a question from my Lord Justice Nugee, about the termination provisions and the fact that you could have this scenario of where you have a concurrent lessee, the operator just sits there, given the solution that the Deputy President provided for. We can take no action because the wording, as you've seen, is really identical. The feature of the code is there are a couple of features that appear on the face of it to be indicating that the concurrent lessee should be treated as a party. We have the position in relation to the ancillary code rights position, the position that I identified earlier. If it is the case that the primary purpose is not to confer code rights, but ancillary code rights, the concurrent lessee is able to renew or terminate because the matter is then dealt with under the 1954 Act. In relation to the transitional provisions, I haven't taken your lordships to those, but the Deputy President, in his judgment, paragraph 58, made it clear, and I think this is accepted, that if one were dealing with an old lease under the terms of the Landlord and Tenant Covenants Act 1995, that is to say a lease which was granted prior to the 1st of January 1996. So where you have an old lease, the grant of the concurrent lease would take effect as an assignment of the reversion for the duration of the current lease.
That's because of what?
That's because of the. That is because of the provisions of sections 141 of the Law of Property Act 1925.
Right.
Which says what?
Unfortunately, it's not in the bundle, but that.
It says the benefit of covenants go with the reversion.
Yes, that is right. But then, of course, because it's an assignment, you are.
But why? Why is it an assignment?
Well, that is what that.
Why is it not a lease?
Because it is an assignment pro tanto of the reversion, pro tanto of the duration of the concurrent
You don't
lease.
get that out of section 141 or 142, do you? Is it some ancient common law learning?
It may be a common law feature. Let me just find the passage in McGarry, if I may. Yes, if one turns bundle 2, page 519, tab 30. Your lordships have that. Paragraph 19.13, 113, sorry, 113. Right to enforce any tenant covenant. And this is commentary on the 1995 Act. The Act provides that the following persons can enforce the tenant covenants and any right of entry, except when they identifies who they are: the landlord who granted the lease, the lessee of the reversion, and mortgagee in possession. Marked a departure from the previous law, though the difference may be more apparent than real. In relation to pre-1996 leases, a landlord ceases to be entitled to enforce the covenants if, and to the extent that some other person, such as the lessee of the reversion or mortgagee in possession of the reversion, becomes entitled to the income of all or part of the leased land. Furthermore, as regards any pre-1996 leases, any subsequent grant of a lease of the reversion operates pro tanto as an assignment of the reversion.
Have we got paragraph 16.134, which is the authority for that proposition?
No, we don't. I shall endeavour to have that after the lunch adjournment.
Sounds a bit counterintuitive.
That is how I've always understood it, but I will check that particular provision. Assuming that is right, assuming that the reversion operates pro tanto as an assignment of the reversion, whereas the grant of a lease of a reversion on a post-1995 lease must take effect as a lease, not an assignment, then we have a scenario, of course, that in the case of an old lease, as it's described under the 1995 Act, if the concurrent lessee becomes a concurrent lessee over an old lease, pre-1st January 1996 lease, it is then treated as a successor in title because it's obtaining an assignment of the reversion. It is an assignee. It is successor. Whereas under the 1995 Act, if it becomes a concurrent lessee over a lease that is granted after the 1st of January 1996, it's not treated as a successor.
Which is the relevant lease for this purpose? The concurrent lease or the operator's lease?
The operator's lease. The operator's lease. So where the operator's lease is pre-1st January 1996 and the concurrent lease is granted over that, then given that it takes effect or operates, it would appear, pro tanto, an assignment of the reversion, it's an actual assignment of the reversion, you are then a successor in title. Therefore, you are a party to the code agreement. And yet, if the concurrent lessee takes a concurrent lease over the operator's lease being granted after the 31st of January 1995, then you're not a party to the code agreement.
So on your analysis, if you are the concurrent lessee in relation to an old operator's lease, you serve your notice proposing a new agreement. The new agreement is then granted. You suddenly stop being the site provider, the relevant site provider, because you are now...
Well, if you conferred it, then you will be a party, will you not? If you...
I see, you would be a party.
You will be a party because you've conferred it. The other point to note about the 1995 legislation, 1995 Act legislation, is that it does contain provisions for the grant of what it calls overriding leases.
Yeah.
We see that at tab 18, page 371A.
This is to original tenants and guarantors.
Yes,
Yeah.
it is.
Yeah.
So the 1995 Act itself contemplates a regime for enabling a tenant who is being sued by its superior the landlord up the chain, it was possibly it was an earlier tenant, right, a former tenant, to an overriding lease. So in those circumstances, the 1995 Act was contemplating that there could be an overriding lease or concurrent lease. And in those circumstances, if you had the simple example of a landlord granting a tenancy to the tenant assigns to T1, T1 grants the operator a code agreement, T1 defaults, L sues T under his AGA, an authorised guarantee agreement. T then seeks an overriding or concurrent lease. He's then not a party to the code agreement of O, the operator in occupation. So that would frustrate the purpose of the overriding release regime of the 1995 Act in the case of code agreements.
But the overriding lease is inserted, is it not, between the landlord and the landlord's original lease, which is now vested in T1.
Yes. But you're still not a party to the code agreement of O.
Which you wouldn't expect to be, because that's even further down the chain.
Well, T1, let's assume if T1 were to be dissolved and T is still not, T, the original tenant, would still not under the overriding lease be able to deal with O. I mean, what if, for instance, T1 were to, if T1's interest were to be terminated in some way, then you would have a scenario, I agree. T is above T1, that is right. That is the scenario, but T is not going to be treated as a party in circumstances where it was intended to ensure that it could deal with the property. So what it would ordinarily expect to do is to be able to, for instance, let's say, terminate the lease of T1 by forfeiting it for, in most cases, non-payment. So you'd have a termination of T1. O, as the operator, would be entitled, pursuant to paragraph 30, to continue because its contractual interest has come to an end, but that doesn't matter because it's continuing under paragraph 30. Then T is unable to deal with O, albeit T1's interest has disappeared. So T, under the overriding lease regime, is meant to be able to deal with the property to ensure that now it's being sued by the landlord, it has an opportunity of dealing with whatever interests are below it. It terminates T1's interest, it cannot deal with O.
What happens to O's rent if the lease gets forfeited?
If the lease is forfeited, under paragraph 30, the code agreement continues. Who is the party to that agreement? Would appear to have been T1, but T1 is no longer in existence. Now, does that matter? Because paragraph 30 simply continues the code agreement. It doesn't require, on the face of it, for there to be another party in existence.
If the operator would prefer to have its lease reinstated, could it not apply for relief against forfeiture? Rather than simply rely on a continuation under the code?
But it may find it's beneficial to rely upon continuation under the code, because in the circumstances where T is unable to deal with O, why not? You have a beneficial rent. It's the absurdity example, perhaps said to be an extreme example, I don't know, but the example of where the operator just decides to sit there. Very happy, thank you very much. Nothing can be done.
So he's got a beneficial rent. Does the rent go to T in those circumstances under the operator? So T has an overriding lease. He's forfeited T1's.
As a matter of landlord and tenant, probably the rent would be due to T.
Yes,
because T
he's
was
been granted the rights
under the 1995 Act. That's right. So he would be entitled, as a matter of landlord and tenant, to the rents, to sue for those. He's entitled to enforce the covenants. But for the purposes of the agreement as a code agreement, we have this bizarre outcome that he cannot renew it or terminate it. That it is impossible to discern any policy reason as to why that should come about. And in terms of how did this failure in the structure of the code come about, it's difficult to say. I mean, there are a number of possibilities. Either the drafter thought that he had dealt with it had dealt with it, or it was simply overlooked. That, I think, was what the Deputy President thought at paragraph 107 of his judgment. So either there was a drafter thought he dealt with it, or it was overlooked, or one has to conclude that the omission of the concurrent lessee from this scheme was deliberate. And as we say, we find it difficult to see why one would reach that conclusion. What is it about?
I take it there's nothing in the Law Commission that
Law
shows
Commission,
any discussion of...
no discussion about concurrent lessee.
Is there this discussion of chains of interest generally?
No, there isn't, my lord. No. There is simply a reference in the to the.
There's a reference to they say that leases will look after themselves.
Leases will look after themselves, and they based the, for what it's worth, they based the continuation provisions that we see on the 54 Act. If we turn to tab 29, page 503 of the second bundle of
I
authority.
mean, you've given lots of different examples, mortgagees in possession and so forth. Will the Law Commission consider any of those?
I shall check over the lunch adjournment, but I believe not as a specific category of heading.
Right.
I may have mentioned. Yes, paragraph 6.79 at page 503. This is in a discussion about continuation. Do you have that, Will? Paragraph 6.79, page 503, second bundle, tab 29. Beginning, we are impressed by the arguments. We are impressed by the arguments in favour of the 1954 Act, which is well respected and whose provisions appear to operate for the most part smoothly. We are also impressed by the observations made by code operators to the effect that they would be greatly supportive of a right for landowners to have the apparatus removed when they wish to redevelop the land. Accordingly, we are attracted to the idea of adapting and incorporating within the revised codes the regime found in the 1954 Act, while eliminating the current dual protection. As you may know, my lords, prior to the new code coming into force, it was the case that a code agreement could fall under the 1954 Act and under the code. That dual protection has now been removed, where the primary purpose of the code agreement is to confer code rights. It cannot fall within the 1954 Act. So, just pausing there before we look at anything else, we find that 1954 Act scheme reflected in the code because we have service of notice for renewal and termination, grounds for termination, requirement to issue proceedings, and like the 54 Act, the claim for termination doesn't give you the right to possession. If you succeed under the 54 Act in your ground of opposition, it doesn't give you a right to possession, like equally under the code. If you succeed in your ground for termination, it doesn't enable you immediately to obtain removal of the electronic communications apparatus. It doesn't enable you to obtain possession. You have to then issue a Part 6 separate claim. So that scheme of protection, of a continuation of rights, under the 54 Act by continuing your occupation for business purposes, under the code by continuing to utilise it for the code purposes, service of various notices for renewal or termination, followed by separate proceedings to get possession. It's the same sort of scheme. And of course, under the 54 Act, concurrent lessees were dealt with because of the definition of competent landlord. Because the code had to deal with leases and licenses, you can't have this sort of requirement of a definition of competent landlord because it wouldn't work. So there was a continuation of those, and sorry, my lord, I've seen you put it away, but that's because I was failing to refer you to a further paragraph. But if you'd be so kind as to look at 695. Apologies.
Yes, continuity.
Yes, so continuity of code rights. We begin with a recommendation that draws on the language of the 54 Act by providing for code rights and leases granted primarily for the purpose of conferring code rights to continue when they would otherwise have expired, along with any terms and conditions on which they will confer. This will bring to an end the situation where code rights expire but the equipment remains on land, no longer subject to any obligation for the code operator to pay for the presence, etc. So there was a continuation of the lease. That is what was envisaged there. But in terms of hierarchy and in terms of party, there's no reference in the Law Commission report to a requirement that you had to be a party. It was talking about site providers. We see that at 698. Giving notice to determine code rights. As we explained above, our recommended regime has two branches. The first relates to site providers, defined in this report as though those who have conferred code rights or have had code rights imposed upon them or are bound by code rights. That's what they were thinking. And that's reflected in the recommendation at 6.102. So it would appear that there's no reference, and I've certainly undertaken various keyword searches of the Law Commission report. There's nothing about concurrent leases, overriding leases, or anything of the sort, or any hierarchy of interests.
Did they produce a draft code?
No, they didn't.
So they produced a report. Parliament accepted most of the recommendations, but not, I think, all of them.
Subject to a number of matters, particularly, for instance, in relation to consideration. Yeah. The government moved away from the recommendation. The Law Commission actually recommended market rent. Government said, no, you're not having that, and that's what happens in paragraph 24. In paragraph 24, you moved away from the market rent. You disregard the use which gives rise to the highest rent, namely electronic communications use. You cannot have regard to that necessity consideration.
You just get the rent you would get for any other use.
For any alternative use. That's right. So it's a dramatic reduction in rental level. And that's what's happened.
And then it was presumably given to parliamentary draftsmen to produce the code.
To produce the code. That's what we see. A number of the recommendations, quite a substantial number of the recommendations are included. Particularly this regime, this new scheme, basing it upon the 54 Act, excluding, providing for continuation, service of notices for renewal or termination, and then separate proceedings for possession.
Right.
Yes. So, yes. So what I say is that there are three possibilities. As I say, either they dealt with it, it was overlooked, or it was deliberate. We say it cannot have been intended that you carve out the position of a concurrent lessee so that it is unable to deal with the operator. That couldn't have been Parliament's intention. Difficult to discern any policy why that should be the case, and in a way one can obtain a modicum of support for that view from the decision, the speech of Lady Rose in the Compton Beecham case, paragraph 117 of her report. If we just look at that for a moment, which is in tab bundle 2, tab 14. Paragraph 117, my lord, of page 317. And at the beginning, first sentence, Lady Rose says, both the old code and the new code indicate that the negotiation of voluntary agreements between the parties for the conferral of code rights is the optimal way for the regime to operate. Now, if that is right, if that's the starting point for the regime, one would have thought that the person that is the only person that can deal with the code by negotiation, namely the concurrent lessee, should be capable of implementing the statutory procedure for renewal or termination. It's odd, to say the least, that we suddenly drop out of the picture on statutory renewal or termination. So I say that's a modicum of support. There are, we would submit, also other textual indicators. None of these particular points I'm about to make are conclusive in their own right, but like a lot of matters when one comes to statutory interpretation, it's an accumulation of points that one is trying to identify to see where the thrust of the argument is going. So if I may just make a number of other points in relation to code. A minor point, it is of interest that paragraph 10, actually its heading, insofar as one can draw anything from the heading, is a modicum of support, but it just simply deals with who else is bound by code rights. It says nothing about being a party. And the second point I've made already, but if I may just repeat it, there is no reference back in part 5 at all, whether it's paragraph 30 for the renewal or, paragraph 33 for renewal or paragraph 31 for termination. There's no reference back to paragraph 10. The reference to the site provider who is a party to a code agreement, it doesn't say if and only if you are a party in accordance with paragraph 10. The point that I made when we were going through the code about paragraph 16, subparagraph 5, about being liable, continuation of liability, if you do not give notice to the other parties to the code agreement. So the most likely person is going to be us. And I've already dealt with another point, is the point under section 17, subparagraph 3, about the question of additional burden being no additional adverse effect on the other party's enjoyment, and also no additional burden on the other party to the agreement. I've made the point that where the draftsman had wanted to be emphatic, he did so. We see that actually, if one turns to paragraph 20, apologies, my lord. Yes, if we go back, apologies, we go back to paragraph 16 in the bundle, tab 21, page 420. This is dealing with assignment of code rights. And then we looked at subparagraph 5 about having to give notice in writing to the other party to avoid the continuation of liability. And then it says, the assignor is not liable for any breach of a term of the agreement that occurs after the assignment if and only if.
Yeah, and you've got that phrase recurring.
And you have that phrase
like
recurring
paragraph
in
21, for instance.
Yeah, 21.1 for reference purposes, 26.3, 37.1. There's 4 places in the code. 16.5, 21.1, 26.3, 37.1. And there are also other references to only if in 5 subparagraph 3, 41 subparagraph 8, 82 subparagraph 4.
These references are all in your skeleton, are
I will supply that this particular point is not in my skeleton. So it's an afterthought.
they? Right, well, if you want me to write them down, you better say them again a bit more slowly.
Sorry.
Right, so we'll
Yes.
start off with if and only if.
If and only if is to be found in 16 subparagraph 5,
Yeah,
paragraph 21 subparagraph 1,
yeah.
paragraph 26 subparagraph 3,
26.3, yeah.
37 subparagraph 1, then subparagraph, we have then only if, the phrase only if, in paragraph 5 subparagraph 3,
Yeah.
paragraph 41 subparagraph 8, paragraph 82 subparagraph 4, and paragraph 85 subparagraph 7. Thank you, my lord.
We don't have 82 and 85 in the bundles.
They're dealing with compensation, my lord. As I say, I shall endeavour to provide those in the bundle. Apologies, my lord, in relation to that. Our position is that when one looks at the code and how it's meant to operate, optimal way is negotiation. We are the occupier. We are the person that is able to reach agreement. It is difficult to see why the terms of the code should be read in a way which precludes us from being treated as a party to a code agreement. And in those circumstances, we say that paragraph 10 should not be so read, and that when one reads part 5, dealing with renewal and termination, we should be treated as a party to a code agreement. That's our primary case. I do have a secondary case, which I'll mention in a moment, about the Pelosi case. It's a little bit more difficult, I would accept. But, well, another point I wanted to mention, dealing with this issue about being a party to a code agreement, I've identified in the skeleton, our skeleton argument, at paragraph 38, page 28 of the core bundle, a number of other examples where this problem could arise if you say, one's surrender, one's merger, one's mortgage. The mortgage needs a little elaboration, in that, of course, it was meant to be said, it doesn't, but the example is meant to be where, of course, there is a mortgage granted before the operator's tenancy is granted before the mortgage. So he takes subject to it, but he's then not, because the mortgagee is treated like a concurrent lessee, he's not treated as a party to the code agreement. It's not a successor. So those three examples are examples where the problem would arise, the same sort of problem would arise.
It's only if the mortgagee goes into possession that the problem arises?
Well, he's still not treated as a party to the code agreement.
Yes, but mortgagees who aren't in possession, you wouldn't expect them to be negotiating.
No, but the mortgagee in possession is still, it would have seemed, not treated as a party to the code agreement, which is, again, an oddity, which our solution is an easy fix with respect. All these problems that I'm identifying arise only because you have this impediment about being treated as a concurrent lessee, as a party to a code agreement. They simply fall away, all of these particular problems I've identified. And that's why we say this court should find in our favour.
Do you say you should be treated as a party to the code agreement, or you are a party to the code agreement?
I'm not sure it matters much, my lord. For the purposes of the solution to the problem, Part 5 requires me to be a party to the code agreement. I see no reason why the court could not find that someone in the position of a concurrent lessee is to be treated as a party for the purposes of the code. That's a purposive construction that one can give to the statute. One is not distorting the words of Part 5. You're adhering to the words of Part 5.
What's the difference? If you're treated as a party, then for the purposes of Part 5, you are a party.
I put it, I suppose, in the way of being treated as a party, because the 1995 Act just gives me the entitlement to enforce. I am not a party under the 1995 Act. It doesn't take effect as an assignment. But yes, I accept what your lordship has said. If you're treated as a party, you are a party. It doesn't matter if you're treated as you're deemed to be a party. Treating someone as a party is a deeming effect.
Yeah. So, in effect, you say that we should follow Compton, Beecham, ask ourselves how this code is meant to work, and just make the language conform to that idea of how it's meant to be.
Yes, that's right. That's right. That is so, my lord.
can I just be sure of how you get there as a matter of statutory interpretation? The question is, are you, a concurrent lessee, party to the agreement, the code agreement, for the purposes of
Yes.
Part 5, paragraphs 31 and 33? Because only those people can terminate or propose modifications or renewals. You've just accepted. Under the 1995 Act, you're not actually an assignee of the agreement. You're not actually a party to the agreement.
It doesn't say that.
What it says is you get the benefit of the governance, the benefit of the rent, the right of re-entry, and the burden of
Yes.
the governance. Your submission is that when construing the phrase party to an agreement in Part 5, it's wide enough, given the purpose of the code, to include someone who's not actually an assignee of the agreement, but is entitled to the benefit of the governance,
Actually, so, my
and
lord.
in
Yes.
the position to negotiate and grant new code rights.
Yes.
That's
That
what
is my submission.
That's what it comes to.
That's what it comes to. One has to, forgive me for saying this, but one has to work in the real world in relation to these matters. And an operator would ordinarily expect to deal with the person that is its immediate reversioner. And why would it think that it has to deal with anyone else further up the chain? That's renders the code as it was intended to be a simpler form of ensuring that code rights could be renewed.
Can I go back to an example my lord gave you earlier? Suppose the concurrent lessee only has a short time left to run, a few months left to run, a few years left to run, and what the operator wants is a new 21-year term. What happens then? Because you say you would expect to deal with the concurrent lessee, but in such circumstances, and the 54 Act caters for all this.
Yes, 54 Act caters for that, that is so.
The operator might expect to deal with both the concurrent lessee and the freeholder.
Yes, but as my Lord Justice Lewison mentioned, one would anticipate in those circumstances that you would have a renewal under Part 5 together with a Part 4 claim requiring the
freeholder to be bound.
to be bound for the
bound.
yeah, to be bound.
So you could do that all in one.
Well, I see no reason why that couldn't. Or what one would have to do would be to wait for the concurrent lease to expire. Your rights then continue under Part 4, and then you'd make a claim under Part 4 against the superior landlord.
But you wouldn't have a 21-year term on my lord's example. It would be chopped off.
It would be chopped off, yes. It would be chopped off in that scenario. Does that is there anything left in the question, my lord? I'm not sure.
Well, I'm still sort of puzzling, because what does the concurrent lessee do if he's got a few years left to run? Because your point is the decision of the Deputy President leaves your client, the concurrent lessee, unable to deal with the property, unable to deal with it under the code. You always deal things voluntarily, but there's no incentive on the operator to negotiate with you, because you can just sit there. So you want the concurrent lessee to be able to initiate proceedings, but what could he do under Part 5? Can he say, well, I've got 6 months left to run, here's a six...
Well, if he has a limited interest, then of course it may be that the renewal provisions and the termination provisions are irrelevant to it. Unless its interest as concurrent lessee has some form of provision for extension, contractually or even under a statutory regime. For instance, it could be a tenant of an office block with the code agreement on the roof may want to seek to argue that
it could be. I mean, yours is excluded from the 54 Act, isn't it?
mine. Well, the Vodafone interest is excluded.
What about your
Mine would. Yeah, mine. Obviously, assuming we're coming back to the facts of the case. Sorry.
Yes.
On the facts of the case, yes, mine is excluded from 54 Act. Yes, on that case, mine would end on the contractual term date. Apologies, my lord. I was thinking about the structure generally, but yes, you're right. I mean, if there's a fag end, as it's commonly referred to, possibly the immediate site provider is not particularly concerned. The person most concerned would be the person up the chain, and then there's no provision in the code, in fact, to require superior interest to be joined. The only provision that one sees is that provision in paragraph 23 of the code. Paragraph 23, page 425. 425. This is about things that... This is under Part 4, of course, but this applies to any renewal. We saw that on the provisions of paragraph 34. So this is a provision that is taken into account on a renewal. So we have various things, but subparagraph 5 of 23 says the terms of the agreement must include the terms the court thinks appropriate for ensuring least possible loss and damages caused by the exercise of the code right. Notice the exercise of the code right is being is contemplating, of course, that this is really dealing with conferral, not binding. It's an exercise to persons who occupy the land in question. So possibly if you had a concurrent lessee with a fag end who decided to implement renewal, the interests of the superior interest would be taken into account in some way. But in terms of actually ensuring that there is some form of agreement by Vodafone vis-à-vis the superior interest, it would have to make a claim under Part 4. There is, in relation to this first issue about the application of Part 5, a sort of fallback argument, which is based on the meaning of successor in title. In terms of what I say about that, I believe what I've said really is everything we say is really contained in our skeleton, which is paragraph 46 onwards. Skeleton argument, core bundle, page 31. It is very much a fallback position because I am asking the court to be a little bit more creative, because the words are successor in title. And what I say in relation to that is that successor in title can be a person who succeeded to the reversion. I have succeeded to the reversion because I am the person that's entitled to enforce the covenants. I am the immediate reversioner to Vodafone. So it is a solution. I accept that it is more difficult as a solution because one is having to deal with what on the face of it appears to be a term of art.
Well, it's not only the word successor in title, it's successor in title to that interest.
To that interest, yes, that is right.
What is that interest?
Well, that interest must be the interest that it had. So, but that interest would have to be interpreted as meaning the interest and being the reversionary interest. Now, it is true I'm not a successor to the freehold, but I am a successor to the reversion in the sense that I do have the reversion entitled to enforce the covenants under the 1995 Act.
Yes, but if you look at 10.2, it starts off, if O has an interest in the land when the code right is conferred, and then you have to be a successor in title.
That interest. I accept it's a much more difficult argument.
That interest.
I accept that. It's
and
a fallback position.
In a sense, you're not a successor because you're concurrently entitled with Gencomp to enforce the covenants. So you may be a successor to the reversion, but you're not a successor to the right to enforce the covenants, are you? You have become
I'm concurrently entitled to enforce, yes.
Concurrently entitled with Gencomp to do that.
But if I've succeeded to the reversion which carries with it the concurrent right to enforce, I'm still arguably a successor. But it's not at the forefront. Our primary case is the case that I presented earlier this morning. I believe, subject to your lordships, that would be a convenient moment because I was going to turn to the second issue about the question of the application of Part 4, the Deputy President's solution and the extent to which that's appropriate or inappropriate. If that's a convenient moment.
Yes, all right. How are we doing for time?
I have a bit to say on the Part 4 argument. I will certainly finish before the end of the afternoon, I suspect.
So.
Yes.
All right,
I shall finish before the end of the afternoon.
5 to 2.
Thank you so much, William.
All right.